In December 2010, an attorney associated with Jim Simons, the billionaire founder of the hedge fund Renaissance Technologies, submitted a secret application to Bermuda's highest court. He was seeking approval for a set of changes to a trust fund Simons had quietly maintained on the island since 1974. Getting approval for the changes, which included adding his charitable foundation as a beneficiary of the trust's fortune, required Simons to give the court, under seal, data relating to his overall wealth. Simons' legal team insisted that such filings must be limited. The exact quantum of Simons' wealth was a strictly private matter, trust lawyer John Robert Balfour Richmond argued. A Google search against Mr. Simons' name will throw up any number of estimations of his or his family's wealth, Richmond wrote in a secret affidavit filed with a 2010 request. Wikipedia, citing Forbes for example, states his wealth as being $8.5 billion. However, Richmond knew something that Forbes apparently did not. In addition to his billions of dollars in US assets, Simons had amassed $7.25 billion in a low-profile Bermudan trust that is one of the largest private trust funds ever discovered. A confidential accounting document attached to the 2010 filing indicates that the offshore trust was projected to grow to $35 billion by 2030. Details of Simons' Bermuda-based trust fund, called the Lord Jim Trust, were uncovered by the International Consortium of Investigative Journalists after a cache of 6.8 million files were leaked from the offshore law firm Appleby. The leaked documents offer a window into the largely unexamined world of offshore trusts, which allow the wealthy elite to store, protect, and grow their fortunes under a veil of financial secrecy. In general, trusts allow people to hand over technical ownership of assets to trustees, often a trust company, to use in accordance with the client's wishes. Offshore trusts can be used to add an additional layer of complexity to the chain of ownership. For instance, an offshore trust in Bermuda can own assets in Taiwan for beneficiaries in, say, California. Some foreign trusts, like Simons, hold the assets of a US citizen, but are regarded as foreign taxpayers, meaning that they conform to different rules of taxation and disclosure without breaking any US laws. Further complicating the blurry ownership of offshore trusts is the lack of transparency with which they operate, and obviously such secrecy has been increased by tax havens. Bermuda is one of numerous jurisdictions that do not require trusts to declare their existence by registering with local government authorities. Trusts are now the most important, complex, non-transparent issue of the entire financial world. Said Jeffrey Winters, a political scientist at Northwestern University who studies economic elites, there's a reason why this might feel like a hall of mirrors. It's designed that way. According to the leaked data, offshore trusts accounted for the third largest single area of Appleby's business. By 2014, the leaked files contained information about more than 2,600 offshore trusts linked to individuals and companies from more than 100 countries. According to the analysis, roughly 2/3 of these trusts are based in the Cayman Islands and Bermuda. Leaked documents from Appleby's Bermuda office show that between 2012 and 2015, the firm provided legal services to at least 5 secretive trust structures that each contained $1 billion or more. In each case, the Appleby file lists the clients as confidential. One of these anonymous clients held 3 related trusts, 2 in Bermuda and 1 in the Bahamas, together containing more than $8 billion in 2015. It remains unclear who's behind this particular fortune. Of course, offshore trusts can also be used by corporations to reduce tax bills. Appleby's files reveal that the private equity giant Blackstone minimized tax payments on large rental properties in the UK, partly by using trusts based in Jersey. Jersey is a tiny island with a population of around 100,000 people, but is home to more than 4,000 trust professionals. These UK properties were held by Jersey trusts, which were then themselves owned by Blackstone subsidiaries in the tax haven of Luxembourg, according to a confidential tax memo. This structure appeared to use loans between these subsidiaries to shift Blackstone's profits from the UK to Luxembourg, with no tax paid anywhere. In response to questions about these tax structures, a law firm for Blackstone responded, "Blackstone's investments are wholly compliant with the UK and international tax laws and regulations. The configurations, according to the statement, were adopted after appropriate advice was taken from leading tax and legal advisors." Now, back to Simons. Before Simons became a hedge fund manager, he was working as the head of the math department at Stony Brook University on Long Island. However, he was investing on the side, parlaying the proceeds from a small yet lucrative investment in a Colombian tile factory, believe it or not, into larger and more profitable bets. In 1974, Simons and the prominent mathematician Chern published the Chern-Simons theory, a geometric model that would later be incorporated into the study of string theory and identifies Simons as a pioneer in his field. In August of that same year, a Colombian industrialist and friend of Simons, Victor Shaw, established a trust for Simons in Bermuda called the Lord Jim Trust. In a statement, Simons said the trust was a surprise gift of $100,000 from Shaw, adding that Victor could have established a US trust, but he chose Bermuda. Because it was established by a non-citizen, the US tax authorities obviously considered the trust a foreign entity, and this limited the IRS's ability to tax the trust fund until it made distributions to its beneficiaries. One feature of Simons' trust was its delaying the payment, perhaps forever, of billions in tax dollars it would owe to the IRS if it ever paid out its fortune to the Simons family. A large portion of the trust would go to a tax-exempt charity, thus helping both to fulfill Simons' commitment to philanthropy and to erase the massive tax liability the trust had built up over the decades. Delaying taxes in this way allowed the trust to reinvest more of its income, allowing it to grow to this colossal size that it is today. However, getting money out of such an offshore trust structure is not as trivial. Unlike domestic trusts that must pay income taxes annually, foreign trusts like the Lord Jim Trust often pay much of their taxes only when funds are withdrawn, and those tax bills can be huge if the trust sits untouched for decades. Because Simons' trust had accumulated so much money for so long, it was incurring a multi-billion-dollar US tax liability approaching 80%, according to an accounting document in Appleby's data. This would include more than $200 million in interest charges for the delayed payment of its taxes. This tax liability, which would be triggered only if Simons' family received any of the fund's aging billions, was growing by the day. One projection of the offshore trust's growth indicates that, had it continued accumulating so much wealth, an attempt to withdraw the trust funds in 2030 could trigger a more than 100% tax liability, including some $18 billion in interest charges. However, the billions of dollars of assets that Simons held outside of Bermuda gave him a key advantage. He didn't need to withdraw any of the money from the offshore trust fund in Bermuda for his personal use, so for the most part, he wouldn't. According to tax documents, the trust would afford Simons the ability to continue delaying the huge tax payments while having the option to receive substantial sums each year without penalties or interest charges from the annual returns on the trust's massive investments. Although the interest charges would apply to the money the trust had accumulated in previous years, all timely distributions of the trust earnings within any current tax year would be taxed without any interest charge, so long as the funds were withdrawn in time, according to trust experts and the Lord Jim Trust documents. Trust funds date all the way back to the 12th century, when knights riding away to join the Crusades would leave their property in the hands of a financial protector. Throughout the centuries, however, they've evolved into a favoured means for wealthy families seeking certainty in how their assets are going to be passed down to younger generations. In some cases, the obscured ownership that trusts offer have served other purposes, by providing the means to hide money from tax authorities or from litigants with rightful financial claims. Unlike the trusts of the Middle Ages, many modern trusts, including Simons, are known as discretionary trusts, flexible funds that allow trustees to pick and choose who among potential beneficiaries receive distributions and how much they get. In December 2010, representatives of Simons Trust made a set of changes that, given the sum of money involved, they described as momentous. The trust would be divided into 4 sub-trusts, with Simons retaining a 54% share for himself, his foundation and other charities. The rest was split into 3 new offshore sub-trusts for his 3 children. This was in addition, accounting documents show, to separate trust funds for each child, each containing more than $120 million. Like the Lord Jim Trust, the sub-trust it spun off would make their investments through a shell company in Bermuda called Shine & Sea Limited, which held a stable of funds by Renaissance and other investments, including investment funds managed by other parties. According to an affidavit from Richmond, the trust lawyer, each of the children's new offshore sub-trusts would receive more than $1 billion, as well as massive potential tax liabilities. Yet the new trust still had the ability to enrich the family, according to Richmond. Mr. Simons' children and their descendants are neither excluded, actually nor practically, fiscally, from distributions of current income, Richmond wrote, adding, which itself is liable to be substantial. In 2009 alone, the Lord Jim Trust grew by $1.3 billion. Out of that sum, the children's separate trusts each received more than $15 million, according to an accounting document. According to an accounting projection, the children's new sub-trust in Bermuda could each contain, if left untouched, slightly more than $2 billion today. The quiet residence of Simon's billions in Bermuda begs the question, how much more is hidden offshore? According to Gabriel Zuckman, an assistant professor of economics at the University of California at Berkeley, $8.7 trillion in financial assets of wealthy households has gone missing by being routed to countries, mainly tax havens, other than those where the owners reside. With the growth of the offshore financial services industry, Zuckman said, such arrangements have become increasingly popular over the past 2 decades. In addition to causing headaches for tax authorities around the world, he added, this has complicated the job of those seeking to study and educate the public about the true extent of wealth inequality. This story offers just a glimpse into the secretive world of offshore megatrusts, and a reminder that the Forbes list isn't everything it seems.
I want to get the read now to Sir Elon Rothschild. Of course, he's a sir, so you have to call him sir. He's a big deal. He's also a gazillionaire, billionaire, very successful. Has worked in and out of the media, great writer.